assistant professor of law here at Albany Law School, where I teach various subjects such as criminal law, criminal procedure, evidence, courses that have nothing to do with this particular topic. I also teach one of the new courses at Albany Law School, which is Introduction to Technology for Lawyers, which is one of a capstone program which Albany Law School is looking to develop in order to teach our students about the importance of learning technology and how technology is impacting the business of law, how technology is impacting the delivery of legal services, and how technology is affecting the ways things and knowledge, such as knowledge, is created and distributed, all through a critical praxis. So we want to question and interrogate, do we really need this technology here? We just don't want to take things at face value. So we hope that this conference is a part of a broader effort to train our students not to be just tech competent, but to be tech savvy. Today, Albany Law School is proud to host the first Future of Legal Technology Conference. The speakers that will be joining us in this class, I've known most of them since the days X was known as Twitter. So since 2018, I've been in touch with many of them, trying to host a conference on legal technology. So if it was easy to set this up, it's because I've been planning this for a long time. So I am grateful that the guests that are with us today and the panelists, you will find a very diverse group. They come from areas in law, such as criminal law, housing eviction defense, transactional lawyers, in-house legal departments, environmental law, government, and many other fields. You also learn that our panelists are also award-winning journalists, experts in legal practice management, legal knowledge management, eDiscovery management. They're also access to justice champions, and many of us are bilingual. I do not mean Spanish and English. We speak lawyer, and we also speak information technology. Before I finish, I want to thank Albany Law School, our Dean and President, Cinnamon Carlane, our Associate Dean for Academic Affairs, Rosemary Queenan, Associate Dean of Research and Intellectual Life, Ray Rasha, all our faculty members who are joining us today, and I'm sure will be glued to YouTube once this recording is up so they can go back and see us. I also want to give a special shout out for all the staff who has been assisting me, Sherry, Lisa, Lauren, and Chloe, and Shell, who is back there giving me signals. Finally, want to thank Aileen Levington, who is here as our co-moderator for this event. Today, we will be having 3 different panels talking about legal technology and the law. It has been broken up like the Christmas Carol. So you will be visited by the ghost of Christmas present, the application of technology in the legal space, and the future of legal technology, the next 20 years. Once again, thank you all for being here, and I leave it away with Aileen for the first panel.
May it please the court. I haven't done that for a few years. Let's see if I need the mic. Okay, so I'm on the mic because we're doing this for posterity, which is part of what we're doing with the YouTube video. I'd like to ask a show of hands from those of you who are both panelists and who are here as observers. How many of you consider yourselves techies? Okay, so for those of you who do not consider yourself techies, what is the reason that you're here? Is it because you're afraid of being left behind, or because you don't know what you don't know and you're eager to hear from other people? That's a rhetorical question. I'm not going to put anybody on the spot. So from that vantage point, I'd like us to go right into our first panel. And for that particular group, we have 4 panelists who come from very different segments of the legal industry, but who have quite a bit of areas in common, which is that they all have to understand what drives the adoption of technology. They have to be able to answer the question, why does this matter? What's the problem that we're trying to solve by using technology versus saying, well, it's tech, it must be good. And from that vantage point, what I'd like to put on the table is for each of the panelists to introduce themselves, describe what their particular interest in this is, and then talk a little bit about, at the general level, what is the problem they try to solve? And then we're going to cross-pollinate a little bit about what their areas of similarities and differences are. So I'm going to turn first to Karen Dunn Skinner, who's on the left, and ask her to take it away.
Technology.
Here you go. You can use this.
All right, that's, oh, well, there you go. See, now it's working. Yeah. All right. So I'm Karen Dunn Skinner. Thank you very much, Aileen and Diego, for having me here. I help lawyers do the right work. That is essentially what I do. I was a lawyer myself for 20 years or more. Seems like a long time ago that I sat in court as well, like Aileen. And now what I do is I help lawyers create businesses that they can run effectively, that they can run without working all hours of the day. Lawyers are great at practicing law. That's what they do. That's what they were trained to do. But the vast majority of lawyers actually work in small businesses, right? The vast majority of lawyers are solo practitioners or work in very small law firms. So they are entrepreneurs. Even a lot of the largest law firms sometimes operate like a collection of entrepreneurs who share central heating or air conditioning, depending on which part of the country you're in. And as a result, you have a whole raft of these entrepreneurs who have never really learned how to run a business. They are trying to practice law, deliver great legal services, and do all of that while they're also trying to do everything else that they need to do as owners of law firm businesses. So what we do in our business is we work with them to create more effective and more efficient systems and processes so that they can do all of the work that they need to do, but we get the lawyers focusing on the right work. And for us, the right work is the work that they love to do. It's what we call being in their power zone. So it's the work that they are uniquely qualified to do because they are lawyers. It is the work that they love to do because everyone is more motivated when they're doing work that they love and not trapped in the grind doing the work that just takes up time without delivering value. And that's the third piece. The third piece of being in your power zone is you're doing work that's delivering the greatest value to your firm or to your government organization, if that's where you happen to work. And that's really where sometimes, that is where we see a lot of application for technology. That's where we see lawyers using technology today. And that's where we recommend that people look for ways to use technology. But as Aileen said, technology has to solve a problem. So if you're running your own small law firm, what is the problem that you need technology to solve? You need to look at the activities that you do on a daily basis and ask yourself, is this work that I love to do? Is this work that I am as a lawyer uniquely qualified to do? And is this work where I am adding the greatest value to my organization? If it's reviewing a whole raft of documents in the context of a lot of the things that you do, if it's filing your emails, there are so many things that we do on a daily basis in the practice of law that aren't really adding the true value that lawyers can add. If you think about what it is that people hire lawyers to do, why do people go to a lawyer? They go to a lawyer to solve a business problem or a human problem. And they are looking for the nuance, the insight, the strategy. They're not looking for somebody who's really good at outline numbering in Word. You can hire somebody else to do that for you. You can have technology that does that for you. So when we look at what lawyers do and we think about what is the right work, because efficiency is doing the right work, the right way, the right time with the right tools. What are the right tools to get that legal work delivered? It's not lawyers doing all of it. So when we work with people, we get them to really focus on how they work. So what is their process? Because process comes before technology. What is the process? And in that process, where are you running into problems? So what's taking too long? That is a key question. What is taking you too long to accomplish the output you're trying to produce? What seems more complicated than it needs to be for you to produce that output? And then once you've identified that, then you can start looking for the right tools to help you solve it. Fixing the processes is going to get you a whole lot further than finding some shiny butterfly tool and trying to make your practice fit into the tool. It's the other way around. You got to figure out what the problem is that you need to solve with technology, and then look for the technology solutions that can help you solve it. And I think that's a really good point for you, Lauren, because that's essentially what you help other people do.
It is. Well, on that note,
Would you like my little mic?
I think this might work. Okay, it works now. So my name's Lauren Holupko. I am the Director of eDiscovery and eDiscovery Counsel for the New York State Office of Information Technology Services. Well, that's a tongue twister. We are currently rebranding. We were looking to name the team something with information governance, but we have landed on legal tech. So Information Technology Services, or ITS as a whole, provides technology support for every New York State agency and other small governments. And that could be anything from hardware, software, privacy concerns, policy, procurement, and my realm, eDiscovery, information governance, or finding legal technologies. So my team has an email team, a forensics team, a platforms team that helps roll out these new platforms. And we just formed another team, which is legal innovation and AI. So that will be focused on finding AI products, which we won't even get into today. AI is here, it's not going away. But my focus is just on technologies that help not law firms, but in-house counsel at all of these different agencies. So at ITS, what we've done in the past is found those technologies, kind of pushed them. We create presentations and kind of what you might say, sell them to the agencies, but we've kind of switched how we're doing that. And now we pull the information from the agencies. So we find out what the problems are. We find out, what they would like to see happen faster, more efficiently, whether it's, reviewing documents for an investigation or reviewing 100,000 emails for a FOIL, things of that nature. So we have deputy commissioners of technology that represent clusters of agencies, and we've asked that they speak to their agencies, see what they're having problems with. And some of them even have some technologies in mind, but in general, they're saying, hey, we're still using an Excel chart to manage our cases, or, we're still reviewing emails in PDF. What can we do? So my team goes out, finds those products, and make sure they're in line with what the agencies need and what's going to help them perform their tasks more efficiently so they can better serve the public. So this is fairly new to us. I think we rebranded maybe just a couple months ago. So I am also here to learn and share my experience from the government side.
You need my little mic?
So hi, everyone. My name is Emma Greenwood. I'm a lawyer. I have a business called Greenwood Law Group, PLLC. I wear many hats. One of them is as a national coordinating discovery attorney with the Administrative Office of the U.S. Courts Defender Services Office. The government's very fond of very long names. And I have been in that capacity of federal contractor since 2011. And in that work, I am appointed by federal district court judges around the country on matters that are deemed complex in eDiscovery, which, as many people in the room know, can mean a variety of things. It can mean there are numerous defendants in the case. It could mean there are terabytes of data in the discovery. It could mean the charges themselves are very serious, death eligible, for example. And so I help the lawyers on those cases manage the e-discovery that is global in a multi-defendant matter. And in that way, it means it's relevant to all the defendants on a matter. So I know we'll talk some ins and outs of the kinds of cases that we work on and work that the three of us do. But alongside my contract work, I'm also very happily hired as a helper expert, they call me, but I don't think, I personally don't think that I can ever be an expert. I'm always constantly learning to help lawyers integrate technology into their practices, which is a fascinating topic to me. I should have started by saying thank you for having me on the panel today, because I think this is truly an important conversation that we should continue having, because technology has always been a part of the legal practice, but I don't think it's been discussed quite enough. So I do help lawyers, both from solos to large firms, help with integrating technology into their businesses and into their specific cases. If they have specific case matter, lots of wiretap discovery or social media, we're seeing on pretty much every case on the state and federal side. So I help lawyers manage the discovery on those cases. So similar to what Karen was saying, that they can focus on the legal principles at hand and not be fiddling for an hour to try to open a poll cam video file with some proprietary software. And I see a lot of people nodding, and you know how that feels. I'm really happy to be here and really looking forward to this discussion.
Great. Aileen, did you want to go through your questions, or should we just carry on?
Carry on.
So I wanted to come back to something that you said, which is really getting people to use the technology. And if this panel is really talking about kind of the current state of things, one of the things that we find most fascinating when we go into a law firm and we start looking at how they're actually doing the work, how they're delivering the legal work, so much of what they're still doing is really manual. There are great technologies out there, and sometimes they have those technologies, but often they're not even using a third of what their existing tech stack can do for them, even a third of what some of the really basic practice support technologies can do for them. So when we think about, barriers, you and I were talking before about what the barriers are. Sometimes the barriers are that they are just so busy, they don't have time to learn some of these new technologies, or they start using one or two things that Word can do and they don't learn all of the other things that it can do. They can actually simplify a huge amount of their work. There are amazing legal technologies out there, but one of the things that we work on with our clients is really saying, okay, what have you got already? What do you have in your tech stack, and how can those things work for you to keep you in your power zone? It's something, I keep saying that word because it's very fresh for me, this idea of working in your power zones. We actually just published a book on how to work in your power zone. It's called the Power Zone Playbook. And David will have copies later if anybody wants to have a copy. But the amazing thing to me is that you can save so much time with even some of the most basic technologies. And it's just a matter of having the time, stepping back from that grind that you're stuck in to say, what else could I do with what I've already got?
I think that's a key point, and one that's counterintuitive for lawyers, whether you're a young lawyer or a very experienced lawyer, that stopping to take the time to make that assessment will actually gain you more time later.
Yes.
And that's a very significant concept, a very difficult one, I think, for most people generally to accept. But I totally agree with you.
Yeah, we run into the same thing with delegation. People know intuitively if they could delegate a task, they would save time. They would have then more time for themselves to do the work that adds greater value. but they don't take the time, or they're afraid to take the time to invest in teaching somebody to do the work, or in figuring out how the technology can do the work, because you can delegate to technology. You're talking about your agencies delegating a lot of that manual work to technology. How do you get your agencies to step back and learn how to use the technology?
See if this one works. This one
No.
does not work.
So we actually, you brought up power zones. We try to accommodate what we think our client agencies may be able to do. This is with new technologies. So for instance, I'm not sure if we're supposed to use vendor specific terms, but we just got a review platform that has an unlimited number of features for document review, and we've only rolled out certain features so far. Actually, agencies only have certain permissions to use because we don't want to overwhelm them. So we're trying to be accommodating to what they're willing to try, since some are reluctant to try the product at all, and what we think they may be able to handle on their own. We also provide different trainings based on need. We have videos, we have a guide, but I really like the term power zone. So we really don't want to overwhelm agencies. We want to try to accommodate what we think they can do. And we also think that's a good way to help some of the more reluctant attorneys who may say, I like reviewing this in PDF. It's easy. I know how to do it. So by only rolling out maybe some of the easier features, we accommodate those that are reluctant to try some of the harder features that we will roll out in the future. But we've found so far that's been a good technique, is maybe starting a little smaller.
Baby steps, right? Baby
Yeah.
steps. Do you find the same thing, Emma?
I do. I also think that, just to take a step back, that there's so much technology available out there. And I know at one of the later panels, the discussion will be focused a little bit more on AI. There's all this buzz about AI. AI is actually nothing new. Certain facets of it certainly are, but the use of AI in our profession, whether it be generating transcripts for audio files, draft transcripts, I should say, and things like that are really not new. I think the overwhelm, especially if you're a solo practitioner, can come in two ways. One is certainly cost,
Yeah.
which is something we should probably talk more about, but also choice. There is a lot out there that promises this and that, just like anything else in society, right? So it's really important to me, and one of my concepts when I work one-on-one with lawyers is to, again, sit down, discuss, have a case assessment or situation assessment discussion, however long that might take, time provided, and really try to figure out the right technology tools for the particular individual based on what they already know and maybe already have, resources they already have, and try to figure out just the precise puzzle piece that will help them maybe eliminate a tiny problem that is getting in the way of them moving forward in their practice, or even very specifically on a very specific case.
So Emma, Lauren, and Karen, you've all identified the exact same issue, which is start small, work with what you have. Can each of you give a concrete example of how you went about doing that? For example, Emma, you just referenced the idea of sitting down with somebody and doing a situation assessment. What does that actually mean? Think about a very recent success you had.
Sure.
And Lauren, you talked about the idea of we try to figure out what they need. We don't want to overwhelm them versus giving them exactly what they ask for because they heard about this new shiny object. Think about a specific example and a small example versus a big example, because we can all relate to, gee, I really should have used that feature. And that's the sort of thing I want you to get at. And Karen, think about it in terms of defining what is a process. You've used that term, but what is a process? What does that mean? And how do you translate that into, quote, what is the problem we're trying to solve? And what's the definition of a successful outcome?
Sure.
Emma?
So I will talk specifically about document review in Discovery. As was alluded to, there are online platforms. Many of you have probably used them to host Discovery on them in a way to help you manage and especially search through voluminous Discovery. There are tons of these now. Even 10 or 15 years ago, they were also really, really expensive. Who was court appointed would not be able to use any of these tools because the courts would never fund anything that cost this much. But the costs have gone down in part because the diffusion of that innovation, that being online platforms, has really grown and become very competitive. So there are all kinds of platforms now. There are platforms that are very multimedia focused, meaning if you have a video and audio heavy Discovery set, they can help you manage your review of those. And they're on, I guess, a flip side, for a bank fraud case, for example, where you have lots of checks with both handwritten signatures on them and text on the checks. Those, we kind of dread those cases. But there are platforms that are specifically designed to help you manage and review and search through those kinds of cases. So one example of a success story is, and this is pretty routine in my realm, but we received a case, I couldn't even tell you how many terabytes, several terabytes big, and we needed to host the material, at least some of it, but we couldn't host all of it because we were worried about cost. And so we broke down by file listing very objectively, what do we have? We have X number of videos, we have X number of Excel spreadsheets, we have X number of PDFs. And with software, again, this is not a human being necessarily doing the work to identify all the materials, but with software, you can pretty easily these days generate what we call a file type listing. And it's a very objective, any computer engineer will understand what it means when you send them a spreadsheet that is called a file listing. It just has the file extensions for all of the files, identifying what kinds of material we're working with. And with that information, the big pool of appropriate online platforms gets smaller. And then you ask, maybe, is this a media heavy important case? In other words, do we think that, and I'm sorry, I'm talking about a criminal case in this context, but does the government have mostly evidence of video of people maybe walking by or in a particular location? And are they focusing their case on that? If so, then I have all of a sudden much more focus on the multimedia portion of that very large data set. With bank fraud, it would be checks. So I would want to find a platform that is very appropriate and has a lot of features to search those checks and maybe associated bank information. So with that, I guess what I'm trying to convey is that by reducing the large sort of unmanageable data set, you now have at least compartments of more manageable, maybe not, less overwhelming, but you can identify tools for those subsets of collections that will hopefully make your life easier as you're obligated as a criminal defense attorney, as many of you know, to review the discovery in the case, and you can't really intentionally overlook something just because it's overwhelming to look at.
All right, so I'm also going to talk about document review. So one example where we started small, as I brought up earlier, is our document review platform. While we know that you can not only code documents, search documents, and by documents, I mean anything, all data. You can not only code them, search them, organize them by saved searches, but you can also create outlines, timelines, tie in facts, issues, questions, what have you. So we started small and we've really only been pushing coding. Honestly, our agencies want to be able to sort through emails outside of PDF, as I mentioned. So we've stressed coding, and mass coding particularly is something that we've really driven home in some of our trainings and some of our rollout calls of the product. And some agencies still aren't there yet, but I feel like if I just push that one thing, like, here's an email thread, there's 50 parts to the chain, you can code them all non-responsive or responsive at once. And then there's 50 documents that are coded, you don't even have to worry about again for a while. So that's just one small thing that we are trying to really promote. And then we feel like once agencies get in and start using it for that, start learning how to use the product, start maybe playing around on their own and seeing the other features, they'll realize how great it is, how much more efficiently the review is. And then at that point, and we're getting there now, we're not waiting until agencies ask for it. But once they're comfortable using the coding, using just, a saved search to save all responsive documents that need to be withheld for attorney-client privilege, things of that nature, and they get comfortable, we'll start rolling out like, hey, look, you can also create a timeline, you can create an outline, you can pull anything that you coded as, this specific fact. So I'm looking for that small win. And if it's mass coding, emailing threads, I'll take it. So we're starting there. We're starting small, but we're getting there.
Well, a tactical question. You talked about the agency. Do you have a point person? How do you find champions and individuals in that amorphous agency to be your Trojan horse to help you move this forward?
So all of our agencies absolutely talk amongst each other. They listen to their peers. I'm not sure, I haven't heard success stories discussed between agencies, but when we are discussing the product with agencies that we're trying to roll it out to, because we know how much more efficiently agencies can get the review work done with this platform. So we know. So we will reference other agencies that are using it. And you know what? Maybe I'll start trying to get some quotes, compile some quotes and, positive things other agencies have said. We haven't tried that yet, but maybe that'll be next.
So I wanted to talk about something completely different. I want to talk about intake. And intake is a process. You asked me about process. Intake is a process that every single law firm and even, in-house groups, everybody has to figure out how to take on a new file, open the new file, and get lawyers working on it. So when you ask me, like, what is a process? Start to finish, how does a law firm accept and make a decision to accept a client and get that client up and running in their firm? So that's writ large, the intake process. The problem that a lot of our small firm lawyers run into with their intake process is they are doing it themselves. And it is not in their power zone. 99% of the time, intake should be done by somebody who is not necessarily the main attorney at the firm. There are lots of people and there are technologies that can actually help law firms take on new clients in a way that is a lot more efficient, and the lawyers are not wasting time. And where do they waste time? The problem that so many of our small firm lawyers identify is they get stuck in consultations with people who are not a good fit for the firm. So they're having these telephone conversations or meetings with people who are not a good fit for the firm. So when we start looking at how to improve the intake process writ large, we start with, okay, how do clients come to you? What are the steps, step by step? How does the client come to the firm? Is it by an email? Is it a phone call? Who accepts the phone call? And we actually map it out. So with large sticky notes, we will map out every single process, every single step and touch in that intake process. And we ask people, where are the problems? Where do you run into problems? So I identified one, which is that lawyers feel like they're in these consultations with people who are not a good fit for their firm. And then we look for ways to solve that particular problem. And how can you screen out people who are not a good fit for your firm? And there are a couple of different technologies that we recommend, and they can be simply, you can have somebody who does that screening for you. So you can have a receptionist with a really great script that's on the computer in front of him or in front of her all the time, right? That's like the basic use of technology. It's just a written script. But you can also have some really nice little software platforms if you want to go that direction that do some of that pre-screening for you. So one that we often recommend is Law Broker. It's a program that essentially creates like a little front page for your website, and people make a few initial selections. And it's designed to keep people sticky because it's not just, clicking and filling in a lot of forms. A lot of law firms' intake forms open up on the screen and the client has to enter all kinds of information. And they get partway through and they either don't enter the right information or they don't know how to answer a question that's on the form. So it requires them to do a lot of writing, and these intake forms are often too complicated for them to fill out, especially if they don't have a lot of legal knowledge. And most people don't. Most people are nervous when they contact a lawyer for the first time because they don't have experience dealing with lawyers. They don't know the answers to the questions they're being asked. So what Law Broker does at the front end to pre-screen people before they even get into the firm is what are the areas of law. It creates nice little drop-down menus so that people have information and one or two selections that they can make, and it feeds them automatically into either a stream where somebody at the firm is speaking to them, not the lawyer, because it's not in the lawyer's power zone to have those initial screening calls, but somebody is speaking to them and making sure they get into the system. They receive the more complete form. They have a consultation. They have like an appointment for a consultation. They have their engagement letter if it goes that far. But it starts with this little piece of pre-screening software at the beginning. So if you think about starting small, that is a small, inexpensive legal tech solution to a problem that costs lawyers in private practice a huge amount of time, which is the wrong people end up sitting in front of them on the phone and they have to say, I'm really sorry, I can't help you. Well, no one wants to be in that position. So you're better off knowing that early, referring them out to another colleague in some other firm that can help, or referring them politely to their local bar association to find a lawyer who can help. There are ways to do that referral before they even get into your office. You don't want to be sitting there and not be able to answer the questions and the people in front of you.
To add to that, I think it's very overwhelming in a CLE about technology to not be thinking about cost. I often hear complaints from lawyers that, the big firms, the government have all these resources, right? And so coming in, if a large law firm or the government is your adversary, and I get that face too from the government all the time. I think to empower those of you that are solo practitioners or thinking about going into your own law practice or working for a small firm should actually feel really empowered. Because I'll give you an example of a large firm debacle. And this is a very common one. The firm may have a contract, a very large contract, and over many, many years contract with a provider for litigation support, for database hosting, for example. It might be one of the kinds of platforms I discussed earlier that's very appropriate for a bank fraud case, but not at all appropriate for a multimedia case, as I earlier described too. They're stuck with that unless someone has the gusto to raise their hand and say, I don't think the platform that the firm, have spent all this money on, I don't think this is the right tool for us. That probably won't go over too well for those who may have, not been thinking about how a single platform cannot really fundamentally be appropriate for every kind of case. So as a solo practitioner or small business, small firm lawyer, you actually are very empowered to shop around. And I think going along with what Karen said, sometimes the shopping around is a hard part because there's so much out there. And ask the experts, ask your colleagues who have had similar cases, ask your colleagues who have used different tools, what was their experience with them? And I think you'll find taking that time to examine the answers to those questions will help you figure out which tools you can afford, and you might be surprised Because again, costs have really shifted.
And there's more competition.
And there's more competition, and you might even be better off than the large firm, in the end, if you do so.
Yeah. I mean, we have a group of lawyers that we have a coaching program. It's a group coaching program. And the exchange of lawyers in the group coaching program on which technologies they're using, what works for them, what doesn't, what features in a particular platform they have found the most useful is hugely valuable. And often I think small firm lawyers underestimate what is available to them. And even doing something like a process map and really understanding what your requirements are. So what is it that you actually need, and making a list of requirements is really powerful, because then you can go to these different providers and you can say, okay, well, these are the 17 things that I need to get done. How many of these 17 things can you do, and what's the cost? And then you're comparing apples with apples and not looking at all of these platforms that all look amazing when you go online, and really trying to figure out which one's going to work for you. But then also having that, that sort of network of fellow lawyers that you can ask, and other attorneys that share their experience.
Right now, we are actually going through the process of finding a case management vendor, and that's exactly what we've done. We collected requirements from a variety of agencies, and it's kind of fun to see, what they think will solve the problems, like what will help them streamline just the basic case management, which isn't the focus of providing, whatever the services the agency is providing to the public. It's not your case management system. It's not, working through a SharePoint site and assigning tasks. So we actually collected, I think it was 17 requirements. Yeah. And
So what are some examples of requirements, just to be specific, reports that it generates, access controls? What are some of the things in your list of 17?
So integration, we want a system that can integrate with, your contacts in Outlook or your calendar in Outlook. Calendar reminders, even if it's not integrated, but a reminder pops up, hey, your answer's due tomorrow. You better get working on that. Obviously, security functions, admin functions. There's so many. I can't list them all. There's 17.
There's 17.
The
magic number.
It is mostly, I would say mostly integration, whether or not it will create template documents that will fill in with the information you filled in for the case, different reports. We've had a request for graphs. I don't recall exactly what the graphs would show, but just another reporting feature.
Like nice visual dashboards and analytics.
Yeah. So things of that nature. And we've really have met with quite a few vendors by now and have given them those requirements that the agencies have said, these will help us streamline our case management, will be more efficient. The attorneys will spend less time, inputting the data about the case and where the case is. So it's actually been kind of fun. Our technology team is, every day looking at different vendors because there are so many. So having those problems you want to solve, those requirements, it is helpful to see, what do agencies need versus what can we get. So we have had to report back and say that, we haven't found a case management solution that can also be public facing, for example. Most attorneys don't want that. So we haven't found a solution that can do that. So it's been a give and take, but having those communications about what do you require versus what do you want? Or, what do you think would be helpful versus, what do you just want to play around with? Things like that. So, yeah.
So 10 or 15 years ago, one of the top requests for an online database platform that would be adequate for really any entity to acquire would be, how fast is it? How fast is it with, the internet from my kitchen table? How fast is it from the car on my phone? We're not talking about that anymore because the technology is caught up. So with all of these assessments, I think it's also important to recognize that they're constantly evolving and adopting. Our requests are being logged somewhere, right, from all of our various industries. And Someone's listening because they want to create a competitive product. So these questions that we're asking today are going to be different than even 6 months or a year from now, because the products will have listened to the people creating those products and improving those products. So it's not a start and end point. It's a continuing conversation and assessment.
Yeah, and I just want to jump in on one of the things that you said, which is, what do you really need versus want? And one of the, there we go. One of the tools that we use to get people to really think about what they need versus want is something called Kano's model, and we use it all the time. So if you want to look it up, it's Kano, Kano's model. And it really helps you assess needs based on whether they solve a must-have. So your teams have must-haves, they absolutely have to have them, or delivers a nice-to-have, or a delighter, or a frustrator. And when we're talking process improvement, let alone the sort of whole requirements for a software platform, but when we're looking at process improvement and trying to decide, how to prioritize what we're going to work on, what we need to fix, what problem we need to solve, we don't even get to the nice to haves and the delighters. It's really, does your process deliver on the must haves, and does it solve a major frustrator? And it's the same with technology. Like, there's so much out there, you might not hit all of your nice to haves and delighters, but you need to make sure that you're meeting those must have requirements and you're solving major frustrators. So that's kind of how we look at it, and sort of prioritize the different options based on whether they meet those two key criteria. There's going to always be nice to haves and delighters, and in process improvement with law firms, most of the time, we don't even focus on those at all, because there's so many must haves and frustrators to fix that we stay there at that level.
So summing it all up, you figured out the problem you're going to solve. You've done your requirements definition. You've gotten buy-in as to what the wants or the needs are. How do you do a cost benefit analysis? Because in the end, somebody's got to pay for it. How does the budget constraint factor into this overall analysis?
You want to go?
Who wants to take the first lead in that one?
I can talk about budget. So similar to my colleague to my left, we have budgets in our government work. And again, that's just part of my work. But of course, cost is always an issue. And I think for me, because very practically speaking, what I'm doing is making a proposal to usually a court to sign off on what might be the largest request for funds that a judge has ever seen. And so in that context, you want to educate the court. Just like you'd want to educate your client, your private client, that, hey, this is a tool that I think is really important, that's going to expedite my work for you and move the case along quickly. So I think the analysis and the application, whether it's to a district court judge or to your private client or to your mother or partner, that you're doing this and you want to integrate this particular tool into your life, into your practice, into your case, into your work, is really the same. It's explaining it on a level that is not, that doesn't marginalize what the person on the other end might or might not know. It's very tricky, but I think fundamentally, and this is really important, is that your understanding of the technology, even if it's a basic level, is so crucial to relaying that message effectively. Because if I don't understand the tool that I'm asking a judge to approve funds for, then the judge is going to ask me a lot of questions that I scramble to find the answer to, and you never want to be in that position. So, similar to when my 8-year-old asked me for a toy, I'm like, do you really need that toy? What are you going to do with that toy? How often do you think you'll play with that toy? It's a similar concept that all of us are used to dealing with in our everyday lives. And I understand the seriousness of the question. I'm not belittling the question at all. But I think if we can all step back and remember that we're people first and we're not lawyers first, that we can apply the lessons we've already learned and actually do all the time anyway to get what we want on a professional level and to get the tools we need.
Yeah. And from my perspective, when we're working with smaller firms and you talk about cost benefit, we say, look, like this tool, how much time is this tool going to save you? How much effort is this tool going to save you? How much value is it going to allow you to deliver to the client without working so hard? It comes down to the same thing. How much, most of the time with our clients, it's how much time is it going to save? And across the lifetime of the product, or across, once a week in your email, there are some email strategies for managing your inbox. They can save people an hour, 2 hours, 3 hours. And we look at what is their billable rate, whether they're charging a flat fee and you're using a sort of nominal rate, or they're using the billable hour. You can reduce that to, yes, the software costs you $99.99 a month. That's like, 20 minutes of work. So if it saves you 20 minutes across a month, it's paying for itself already. So when we kind of bring it down to that level, a lot of times what seems like a really big software spend for a small firm, maybe it's, Clio with all the bells and whistles at whatever, $3.99 a month. It only has to save them an hour and a bit of time, and it's worth it. So we do distill things right down to time and money.
So I would say, besides the reluctancy to start using a new technology and maybe change fatigue, budget is one of our biggest hurdles. Government may have money, but I don't think we spend it that quickly. So often we'll have an agency like the review platform, for example. A couple agencies started asking for it 5-6 years ago, and I think it was approved about 2 years ago. So it took that long to come up with a justification and find a vendor with a good pricing model that we could actually get approval for from Department of Budget. And then once we had it, then there's the client agency costs. So we do still have agencies who can't get approval from within their agency to use the product, which is very unfortunate, but we try to really stress, this is going to just streamline your review. It's going to cut the time in half. Say for a FOIL, I found that the email reviews, the document reviews alone are taking maybe half the amount of time that they used to, probably even less. So once it gets past budget, we then have, the client agencies with their restraints, and sometimes it's hard for them to get approval. So budget, definitely a consideration. We have to have very strong justifications, whether it's numbers within hours. We don't usually have billable hours, so that's not usually part of the equation. But even just saying, how much it's going to streamline a review when it comes to hours, cutting it in half, cutting it by a third, like we need to know that and include that in our justification. So
Well, whether the hours
Budget's
are
difficult.
whether the hours are billable or not, you have a
There.
maximum time capacity
Yeah.
that somebody's going to spend at work.
yeah.
And so then it's a matter not of profitability, but substitution of activities. We can open up the floor for questions at this point. 5 minutes or 10 minutes, depending on what folks in the room would like to throw out to the panelists. Bob.
I have a question. Lauren, I think this is for you. I think if I understood you at the beginning of your talk, you said that you've kind of changed your model from pushing technology to maybe more of a pull, to trying to listen, I guess, to what the needs are of different agencies. But a problem I've always seen in law is that lawyers often don't know they have a problem until somebody makes them aware of the fact that there's a better way to do things. They're so used to doing things the way they always have, and it's worked perfectly fine for 20 years, and why change? Right? So how do you kind of manage that fact that they may not even know they have a problem, or that there's a solution to do something a better way?
So
Can you repeat the question for the video?
sure. So Bob asked, if an agency doesn't even realize that they have a problem, how do we kind of let them know or push our product onto them to solve the problem that they may not even be aware of that they have? Is that right? That's pretty close.
Facilitate their insight
Yeah.
versus push.
So often, luckily, we are working with a large number of agencies. So often the fact that there is a problem, or maybe not a problem, but just something that can be done differently, more efficiently, will come from somewhere else. Another agency may bring it up. My example is always reviewing PDFs. Like, why are we still reviewing PDFs like this when we could get a document review platform? So we are really we communicate with our client agencies every day. We're really in tune with the processes that they have and what they might need. We have a specific team, our program team with deputy commissioners of technology that work with the agencies, bring back their processes, bring back what the technologies they're using and the problems that they have, and they tell us. So for the agencies that aren't aware, it's more of a push. We may find a new technology, and our technology team and myself on some of the calls will present different ideas, different vendors that we could work with, different technologies we could bring to them. So it's still kind of a push-pull. Well, we do take the requirements, take different problems that agencies have and try to find solutions. We do also kind of push different solutions, different processes, different platforms on them. So it still works both ways.
Just to add to that, I think that knowing your adversary, speaking specifically on a lawyer-client relationship where your client is maybe, let's say, for example, is involved in a criminal case. What resources does the government have against your client, not specifically on the subject matter, but in technical resources? And we have to talk about that now in this time. So if my opposition, if my adversary has a fancy online database, and I'm just a solo with a client who needs help, I'm going to advocate probably for some sort of online database to be on the same level, just on a technical front. Yes, it's challenging for the lawyer who maybe I've never used an online platform before, but that's where Karen's suggestion to have experts come to help you get your feet wet and know when you have to stop being the lawyer that can do it all, even the non-lawyer stuff, and ask for help. And know that it's out there because certainly it certainly is. But I spend quite a bit of time speaking to my adversaries. I believe strongly that developing relationships, I use that word loosely, but developing professional, cordial relationships where I can pick up the phone, call a prosecutor, and ask them point blank, why did you deliver this to me, this discovery to me in this format, maybe PDF format, when it could have been provided and should have been provided through best practices in a different manner, format-wise. So I think talking to your adversaries is important, and maybe even you'll develop friendships, as I have, with them, where you can casually talk about what kinds of tools and resources they're using, and because we're all sort of in this together. And I think communicating with your adversaries is also part of the equation.
And I was going to say, it's a really good point, because so often when we work with people, they don't see the waste in their own work, because it is, as you say, it's their normal.
Yeah.
And when something is your normal, you don't know that there's another way to do it. And we've spent with our business a huge amount of time sort of educating people about what's value and what's waste. And we came at it, both my partner and I, from the perspective of Lean and Lean Six Sigma. And there's these sort of 8 classic wastes. There's defects and overproduction and waiting and non-utilized talent, just the wrong people doing the work. And, transportation of documents and information and where am I? Inventory and motion waste, which is people moving around, and extra processing. So there are these 8 kind of classic wastes. And when people start to see that, and we give examples of waste, and suddenly they're like, oh gosh, like all those interruptions, that's actually a really important form of waste and delay in my whole practice. So they start to see their work differently. And when they start to see their work from this perspective of what's adding value and what's actually frustrating them and what's a waste, that helps them to see that they have a problem. And also we just ask really basic questions like, what is taking you longer than you think it should? What feels like it's just a little more complicated than it needs to be? Everybody has days when they're sitting at their desk and they're like, this should not be taking me so long. It shouldn't be this hard. And that's when they start to feel like, okay, maybe there is a different way to do it. Maybe there is a platform that can help.
Well, Karen, you referred to Kano's model in terms of what are the frustrators
Yeah.
and what are the delighters.
Yeah.
And behind all of that may be the wastes.
Exactly.
Other questions? Yes, please.
So
Wait, I would actually suggest we give you the
Oh, you
mic,
can
so
have it.
you don't have to repeat it. Thank you.
At the risk of dating myself, I worked at DEC, New York State Department of Environmental Conservation, before they used email. And I was Deputy General Counsel, and we were tasked with introducing email to the agency. It was a disaster.
And arguably still is.
Would you mind coming and sitting up here? People should see you and applaud you.
So there was one, she was not a lawyer, she was a paralegal, and there was a particular document that we used in the agency, and it was called a RONI document. So part of what I was supposed to do was look at processes and say, why do we have this or not have it? And I asked this woman, why is it called a RONI form? And she says, I don't know, but we can't change it. So my question, we recognize that within government agencies, I think in particular, and having been in government and in private practice, there's kind of different kinds of resistance. I'm curious, do you see generational differences in the willingness to look at new technology and adopt it?
Absolutely. And I have to tell you my purple sheet story because it goes with your RONI document. We were doing a process improvement project. We asked, they were telling us about their communications process in this regulatory agency. And they said, oh yeah, and these documents come around and they're the purple sheets. But we were used to put a purple sheet of paper on the top of everything that had to go to legal. And that was fine, except we discovered that purple sheets cost too much money. Purple paper was more expensive than white paper. So we just, we now just use white paper. And she said, but they still say purple sheet. And I'm like, no, there's no way. Turns out, true. She brought me one. And this was like just a couple of years ago. She brings me the communication from legal that's printed out with white cover sheet. And the white cover sheet says purple sheet. Somebody goes and prints out these white cover sheets with purple sheet because that's the way they've always done it. So it is, I mean, it's challenging and it's interesting to watch how people adapt to things. But getting them past that's the way we've always done it it's huge. Did you want to jump in?
Yes, I'll add to that. I do think the answer to your question is yes, there is still a generational difference and different challenges.
Yeah.
However, I think that is shifting a little bit, and I'll explain. So when I started my practice, we were still doing the banker's boxes of discovery, going to not necessarily going to the warehouse like in the movies, but close. And the advent of the DVD or the CD, was just like a blockbuster, and we started getting DVDs and CDs, and a lot of lawyers that I worked with, having just graduated from law school at that particular time, were overwhelmed. They had no idea what to do with a DVD. Forget flash drive. That was, maybe 5 years later, or hard drive. There is a philosophical conversation here that's underlying all of this, which is the diffusion of innovation in society. And I am fascinated by this topic. It's a whole other panel, not in a law school. I don't know where it would be, but I think it's absolutely relevant to our practice of law because we all, again, separating ourselves from the legal profession, are people adopting to technology on a daily, hourly basis. 10 years ago, none of us would really be talking about Snapchat or other social media out there. Now it's part of our lives as people. And so I advise my clients, whether they're in the private sector or government sector, to use technology, maybe not know the ins and outs of everything, but have a Facebook page if you don't have a Facebook page, just so you know, if you have clients that have Facebook pages, that you know how to work your way around it. Because I think our understanding, even on a basic level, of technology and how it's being diffused into society, culturally, sociologically, politically, culturally, all the things, is really, really relevant and will make us better lawyers in the end.
Well, I think you're absolutely right that the diffusion of innovation is core to what we're discussing today. And to the extent that we're doing discovery or creating files, we're doing it in the context of what is the technology, what we have innovated with. So I think we do have to discuss it in this environment. And there are at least 2 or 3 people in this room who I know who have titles with the word innovation in them, and they're in a law school. So with that in mind, why don't we terminate this extensive discussion that will go on afterwards at the reception and move on to the next panel.
Super, thank you very much.
So our first panel, we stayed at a pretty high level, but we asked for specific applications. This panel is going to be much more focused on specific use cases. In law school, I guess we call them hypotheticals or cases out of a case book, but in technology, we call them use cases because they're both focused on particular problems we're trying to solve and also giving concrete examples about how they've been solved. I've asked everybody to make specific reference to the technology applications they use, but they are not endorsements. And by no way are the examples they're given necessarily appropriate for everyone. But I just want people to talk about it in as concrete terms as possible. So we're going to start with everyone introducing themselves, your one moment of self-proclaimed fame, and then talking specifically, just after we go around among the 4 of us, then Alejandro will start with his example based on what he does in, here are a couple of buzzwords, KM world, but which also involves transactional work in a big law firm. So Alejandro, why don't you start?
Excellent. Hello, can you guys hear me? Okay, many thanks. My name is Alejandro Vallallanes. I'm originally from Puerto Rico, now live in Florida. So as you can imagine, it is very cold for me, but I'm having a blast. I'm an attorney by trade, but I'm also a legal knowledge management operations manager. Management twice in the title, but I do work with law firms in regards to helping the law firms manage their collective legal know-how, and we'll get to some of the details in a minute. But that's basically what let's say my discipline, knowledge management, does. We help the law firms manage their collective legal knowledge and legal know-how.
Hello, everybody. My name is Jawad. I'm actually an Albany Law School alum, class of 2015. So it's actually pretty nice to be back here. There's a lot of memories flooding back. I think the few times I was actually in this moot courtroom, I got my butt whooped and decided to go towards the data and technology side and not ever have to litigate. So yeah, thanks to the first panel who was here. We had quite a few people who were also in eDiscovery, so they kind of set a nice base layer. I am also in the eDiscovery world, but from a different perspective. I've pretty much always worked in big corporations. And the thing about eDiscovery, which I feel like fits so well for this panel, is that it really does touch on both technology and law. So, for example, when I was at Morgan Stanley, I was on the technology team, so I reported up to the head of technology. And where I work now at Scotiabank, I'm on the legal team, and I go up to the head of litigation for the United States. So eDiscovery really is one of those areas where it really is an intersection of law and technology. So yeah, thanks for the first panel for setting a nice little layer and base. And then, yeah, I can get into more of the specifics of what I do in the eDiscovery in an actual day-to-day context. Yeah, thank you.
Thank you, Jawad. My name is Mildred Meléndez. I'm also from Puerto Rico, but I came from San Juan, so I'm dying with the cold here. Right now, I work as Director of Admissions in the University of Puerto Rico School of Law. Also coordinate student support, a joint degrees program. So basically, I'm opening the door for a lot of new generation lawyers and it's a pleasure to be here. Also, I've been learning a lot about technology because aside of being a lawyer, I'm a legal project practitioner. So technology is a big part of how we improve process. And also, I recently started a Master of Law in Cybersecurity and Digital Law.
I'll steal
Oh.
that one since you've got the
What?
other one.
There we go.
You're mic'd. Mildred, you're mic'd, so you can turn that on and off.
Oh, perfect.
Okay, super. Here you go.
You're on.
I'm on, okay. My name, yes, best friend and worst enemy at the same time. My name is Val Lubanko. I'm the Deputy General Counsel at Information Technology Services, also known as ITS. I graduated from this law school in 2011. I took civil procedure and property with Professor Brescia, who is in the courtroom now. So it's nice to be back in the DMC, seeing you here from this vantage point, not in the stands. But with my day-to-day operations, not only do I work with Lauren Holupko, the eDiscovery Counsel, but I also work with our adversarial team who handles litigation, HR, LR matters that arise within the agency. I work with our procurement department. Crystal, who also is in the stands here, is one of our attorneys from the procurement department, and they play a very important role for our agency, making sure that we can acquire the technologies that we need to support ourselves as an agency, as well as all the other executive state agencies in the state. Just to give you an idea, ITS operates data centers 24 hours a day, 365 days a year. It includes more than 20 million public accounts, 130,000 employee accounts, 63,000 VoIP phones, and 37,000 mobile phones, 100,000 workstations, laptops, tablets, 16,000 virtual and real servers, and 33 petabytes, I had to Google that one, of storage, and 35,000 virtual desktop remote connections. So that is a snapshot of the technology that our agency supports and that our in-house counsel has to support as well. And we use our own technology in-house in the Division of Legal Affairs to make sure that we can support our agency and the other agencies that are using this technology.
Wow. Alejandro, the floor is yours. And I have the mic. Pass it down.
Excellent. Well, just by quick show of hands, how many are familiar with the term legal knowledge management? Just to, okay, good showing, good showing. Yes, we did a very good job in profiling and raising the profile of knowledge management. So I spent 4 years at Baker McKenzie, and we had a team of around 6,000 lawyers. I've never been in a firm that big. So the amount and the sheer data of legal knowledge and legal know-how that we had at the firm was humongous. So I with the knowledge management team was involved in helping collect all that legal knowledge, all that information that was stored in our attorneys' heads, what we call tacit knowledge, and converting that into, or codifying it into documented knowledge. That could be everything from checklist, workflows, the processes that we follow in certain, or the steps that we follow in certain transactions. It could be sample memorandas, model agreements, lots of different legal documents that have the potential to be reused or recycled or repurposed, right? So when you have a firm of 6,000 attorneys, it's quite a challenge to be able to collect that information and make it available to others in the firm so that they can reuse it. And one of the things that we hone in was sharing of the attorneys that all that information and all that legal knowledge is an asset of the firm. So what we want to be able is collect that asset, store it, and make it accessible or that other attorneys can surface, because that information is super valuable to the firm. The firm invested in the attorneys, they invested in acquiring that knowledge, and want to make sure that we're able to capture it in some way, shape, or form, right? So we develop different processes and systems and services internally to be able to support the attorneys, to help the attorneys capture that. Not only capturing, but also helping them surface new and additional information. So our team in Baker McKenzie, we manage everything from the famous platforms, the Thomson Reuters, the Westlaw's, the LexisNexis. We help with the attorneys as well, but we also help them collect that information, such as all the sample agreements, all the sample memorandums. We help them tag it and codify it and upload it to a database where other attorneys can go in and search for it, right? And the whole purpose is that when attorneys have to create something, they don't start from scratch. They start with at least some base that they can work off, and it saves them a ton of time. Basically, the whole premise is how we can be more efficient and more effective. And one of the ways that we were able to accomplish that was with a technology that's been for decades now, document automation, contract automation. And I know it's been talked a lot, but you'll be surprised of how the challenges that we still have trying to implement document automation in law firms, in big law firms, especially ones that are forward-looking. So we created a system for the firm and the attorneys to be able to automate the contracts that were most used. So we did a process where we identify with different areas of law, different practice groups, which agreements were heavily used. Because the main idea is that we want to have a great return on investment on the work that we do, right? So we identify agreements that were heavily used, and we converted from a flat document, which is basically a Word document, to a, now I forgot the term, flat document to a dynamic document. Is that the term? Okay, thank you. You're nodding. I like your support. So the idea was that we're able to put a form where the attorneys input all the information related to that particular deal or transaction, and then the system will spit out an agreement. It's not going to be 100% ready, but it gets them 90% there, 80% there. And that was the idea. And we were able to save the attorneys on average close to 2 or 3 hours per agreement. And most importantly, I won't say most importantly, but also one of the big benefits was that we were able to reduce the amount of errors produced in these agreements. We're talking about agreements that are dozens or hundreds of pages long. The probability of human error was always there. But once you take the time to automate one single template, you were able to shrink down that margin of error almost down to, I won't say zero because there's always human error involved, but very, very close to zero, right? And number 3, the attorneys that used it, they were able to have other ideas. Hey, maybe we can automate that other agreement, or maybe we can implement a workflow for this other type of transaction, right? It's a door opener, a gateway legal tech to other types of improvements. So that was just one example of how in legal knowledge management, we were able to create efficiencies, be more effective by using automation and some of these legal technologies. And I know that you're also very involved with some of the automations in the eDiscovery world. So,
Yes. All right, thank you all. Yep, my name is Jawad once again. So I am the U.S. lead for preservation and eDiscovery at Scotiabank. And Scotiabank is a Canadian bank, so I do have Canadian overlords, but I got the U.S. So yeah, touching on kind of what Lauren said in the last panel. Well, actually, let me take a little step back and just talk a little bit about what I do. So I do a lot of data preservation. So this is when there's a litigation and we need to put certain data on hold. We issue legal holds. This could be for certain data, individuals, systems. I also do data collection and data review. And this is kind of what we touched on a lot in the first panel, which is document review, which is really the big heavy lift when it comes to a lot of this stuff. So to dive kind of a little deeper straight into this, one of the big platforms that most company uses is called Relativity. So this is one that I've used in many companies that I've worked for. The company I currently work for uses Rel1, which is a more modern version of it. And just to throw out some other names, so I'm not advocating for one company. I've used another platform called Disco in the past, and I know there's one called Everlaw as well. I haven't personally used that one, but I know that is another one of the platforms. So within document review, and I think we kind of touched on this, there's often times where we have to review large volumes of data. And I think, you know, as we said, we review it. By reviewing it, we mean we review it for relevancy. Is this relevant to the matter at hand? There could be other items as well. Is this confidential? Is it privileged? You can go even deeper into a matter and have what we call issue tagging, where if it's a legal matter, and let's just go for an easy example that involves a few different jurisdictions, while we're reviewing the data, we can tag what jurisdiction it belongs to. So that way, when we're reviewing, once again, we kind of have it categorized even more specifically when we're looking back. So one of the early ones that Lauren mentioned was threading and being able to review rather than having to go in and code every single document. Let's say in an email thread, you can code one and that would kind of pre-code the rest of them the same way. But one that we've used recently in one of my matters that I'm working is called Irrelevant Document Identification. So pretty much what it would do is it would review the entire database. So once the data has all been loaded into Relativity, it will do a scan of the entire database to kind of see what documents are irrelevant. But the way it'll do that is typically through out of office messages, through advertisements, you know, blast mails where the recipient count will be 50 plus, 100 plus. So just getting that base level off the top is incredibly efficient. It saves a lot of time and a lot of cost. So for a real world example, we had around 500,000 documents we had to review. After we did this, you know, irrelevant document identification, we were able to remove around 50,000, which is about 10%, which is huge. Back in the day when I was working in document review, overseeing document review teams, we would ask the teams to code or the individuals to code around 60 to 80 documents an hour. So you can imagine 60 to 80 documents an hour times the number of reviewers times the number of hours. If we can take 50,000 off the top before we even get started, the amount of money you're saving, the amount of time you're saving is just, you know, it's just a win-win. So that's one of the items that, you know, we've seen some big technology advances and big wins, and we're actually using pretty often, pretty much every case we're working on. Some other ones which I personally have not used, well aware of, and hoping to potentially use soon in some matters we're working. We call it TAR, or Technology Assisted Review. So for these ones, we have one called predictive coding. And what you would do is, let's say, probably the person most familiar with the matter would go in and code a subset of the documents as much as they can. And then based off of that subset of documents, the computer software and AI would then code the rest of the documents based off of that seed set. Based off the course, they've seen great reviews. They accept this technology. Obviously, you want to do a spot check and make sure everything's looking good towards, you know, the end before any sort of production. And another TAR, or whatever, is called CAL, too many acronyms over here, which is continuous active learning. So rather than pre-coding the documents as you're going along and coding documents for relevancy and all of these items, the software and the AI will now push documents it believes are most relevant based off of your coding to the top of your queue. That way you're reviewing items that are the most relevant to you rather than, once again, going through it and just kind of going date by date and then trying to find sporadically. It'll bring everything to the top. So you're able to identify the most relevant documents, the hot documents, the most important items to the matter, which is obviously you want to identify as soon as possible and earlier on as the discovery process is happening. So these are just some of the technologies that we're using in the day-to-day over here in the eDiscovery world. You have.
Yeah, Valerie.
Oh, okay.
You're up, Valerie.
Oh, I'm up. Wonderful.
We're not sitting in order.
No, don't worry. So not to, belabor the eDiscovery platform, but I just wanted to point out another use case for it. Normally when we have law firms, sort of big corporate in-house counsels, it's used for litigation discovery. And in government, one of the other uses for it is FOIL, Freedom of Information Law. As Lauren had mentioned, when I was the executive chamber FOIL counsel, I did FOIL review manually on PDF. And, we're talking about 10,000 pages, weeks of review. My eyeballs wanted to roll out of my head. And, Bob had asked, well, how do agencies know when they need new technology? I feel like one of the ways that they know is if, a citizen is getting disgruntled about the lag time or response time it takes for an agency to provide a service, respond to a FOIL. And that's when the fire gets lit to say, oh, look, we need something better than just, PDF review. And that's where, ITS and Lauren come into play. And they say, okay, well, look, let's work with you to see how we can, maximize your time, make it more efficient. And we can use an eDiscovery platform to help you with these large volume of FOILs that you can now code and review, and it won't take you as long to do a manual review. So that's something that I wanted to point out, that these doc review platforms are not just being used for, purely litigation purposes, but for other uses as well. And I really wish I had it when I was, a FOIL counsel. Obviously, we also use tools like Westlaw and Lexis. One of the other units in the Division of Legal Affairs is the Legislative and Policy Unit. And one thing that we need to research is, what other states are doing in terms of legislation, particularly now with data privacy, AI governance and things of that nature. We can use these types of search tools, not just for case law, but what other states are doing in terms of legislation and how we can improve our laws as well in that type of topic. And just one other thing to mention, ITS earlier this year, published our acceptable use of AI policy. That is our goal is to give state entities, bumper rails to help them choose a technology that will benefit them, and also make sure that they're using it in a way that is beneficial for the citizens of the state of New York. Obviously, this decision cannot be done in a silo. We always encourage, the privacy officer, the cyber security officer, the chief technology officer, all to opine on what type of product they're looking at, to make sure that they're ingesting just the right amount of information to make it work. So we're not holding unnecessarily personal data for long periods of time, things like that. But again, we want to be able to use these types of technologies because this will, I think, ultimately benefit the citizens of New York to help make these the government services run more smoothly.
Thank you. Well, I want to first ask, and I want the people
who learn by themselves all this new technology to say picture. The ones who learn it on a talk or in a class, say catcher. Higher, I don't hear you. Well, we have a lot of pictures here, right? Because, and I was taking notes, I do my due diligence of the first panel, because I want to find a common ground about how we are addressing technology. And usually the common ground in the first panel was find where you have a problem. And it's very clever and it's a fact for improving and integrating technology, because the legal world has been evolving and have been navigating challenges related to social, to enhance diversity, environmental, and political changes. And also, we have been adapting ourselves to technological challenges for quite some time, and Puerto Rico and the US are no exception, of course. Challenges in Puerto Rico maybe are starting, and maybe we are a bit behind in technology matters, but, and the first panel say it too, artificial intelligence is the hot, sexy topic right now. Everybody's on it because it gets massificated. It's not something new, but now normal people, lawyers, etc., have access to it in a way that we don't have it earlier. And also, we have tools like machine learning, eDiscovery, automation, among others. And as many of you know, Richard Susskind designed a legal grid to show how technology can be used. And he designed this in the 90s, I believe, or 2000s. And it hasn't changed. It's the same approach. And tech law advocates that and emphasize that the benefits of technology in the legal sector are increased efficiency, accuracy, organization, and improved collaboration. And to that, I add access to justice. Because foremost, we as lawyers are officers of the justice legal system. And we have to make access to justice available, and technology should be another tool. And I find some common challenges, and the first panel addressed it beautifully, because we have a lack of technological skills, because many lawyers still prefer the traditional methods. And it's not bad because you feel comfortable. But if you stay behind, you're going to see it. And we could see that this, no matter if you are in any country, there's that hesitant feeling. Also, budget constraints. The budget of a big law firm is not the same for a solo practitioner. And we have to take, I'm sorry, my English is failing, to ourselves to know that, okay, there's comes software, there's comes AI, but also the hardware cannot be left behind. Because if I know you maybe are seeing this, when you are going to buy a new laptop, what have in there right now? AI. So how we have the technology adapted if we don't have the hardware? So that's another thing that we have to consider in our budget. Also, the ethical concerns. We cannot compromise our clients' data, but also we have to have a new approach to how we use technology, because we cannot risk to alienate clients and or more importantly, our team, our people who are going to be the first face when they come to our law firms or to our legal aid firms. And also we have to have and look out for data privacy and security concerns. And that's why a lot of lawyers are concerned of using cloud-based solutions. At least in Puerto Rico, some lawyers like to use Google Drive, but other companies encourage that we use Microsoft because maybe it has more enhanced security. I don't know, I don't want to overextend.
No, absolutely fine. You're making really good distinctions because you're talking about different expectations about security and data privacy and how you might have a particular tool that people have access to, but there are constraints. So keep going.
Well, something that also we are to be aware, and as we say in Puerto Rico, ojo, we are having new regulations and we have to look at the bigger picture. It's not United States regulation, it's about global regulations. Internet is global, it's multinational, and we have to be aware that we have to follow the rule of law of the European Union, Asia, Africa, and Latin America. And that is something that we have to have right at heart because we're willing to risk our own information because every time we use ChatGPT, we are providing our information, but how many of us has really read the use agreements? How you do? You read the terms, you too, but not everybody. Yeah, the instructions are fine, yeah.
So we have a question over there. Do you want to share a mic or come on up or take a mic?
Thank you so much. May I stand?
Please.
Hi, everyone. My name is Joseph and I'm a 1L, but, oh,
So, put it close to
sorry.
your mouth.
I'm a little nervous about
You're on the spot, you're on the spot.
I'm ready for this cold call. So in correspondence to your point, I was thinking, you spoke about using Microsoft as a database, and I thought about Microsoft Teams at that outlet. So that way you'd be able to have the advances of OneNote, OneDrive, Microsoft Word, Microsoft Excel, and PowerPoint as well too. And that way you'd be able to collaborate with your team in order to do these projects. But in the opposition of what you had said, in utilizing Google, and I guess Google has the same correspondence where you're able to use their version of Excel, their version of Microsoft. And I was inquisitive in terms of which one do you find to be more productive?
If you ask me at the personal level, I love Google Drive. I love it. I love the presentation.
I've never heard anyone ever say that. Ever. That's great. That's awesome.
I know I'm strange. I know it. Because
Ray, do you want to set up a SharePoint site?
It's not.
Okay.
I would want to create a better file sharing system, you'll make $1 billion.
but I'm an Android person, okay? So I'm still strange. I know a lot of people with iPhone people. So there you have it. In the personal level, I prefer Google because I find it friendly, more usable from the cell phone. I work a lot through my cell phone. So that's helped me out a lot when I'm trying to edit documents, making presentations. I feel that it runs smoothly. But for my day-to-day work, I have to use Microsoft because in my job area, I work with private data of students, number of students, address, name, GPAs, LSAT points. So I need to be careful with that information. And it's an order for my university that we use Microsoft. The university, until a couple of years, used Gmail, Google, and all of that. And we are really capable of knowing that no matter what do you use, Microsoft, Google, or whatever, there is a risk when we are using online tools. There's no, our documents are not in jail exactly, because always someone can run a scam, someone can get in our emails. So we have to be diligent on our side, but also we have to be diligent with the changes they do in their policy about how they manage our data. And that is really important. And that's why everybody who is using artificial intelligence, be aware, because we don't know how they're using our data. And now I believe something that a lot of people are doing is using ChatGPT to improve their resume. So how many information are you putting there that is important to you, but you're giving that information to ChatGPT, who is learning about yourself, who is learning about you? Also happens in the email. You're putting ourselves there, the chats, the video calls. So I believe that's something you have to think about. Yeah, in the personal level, I'm going to be using Google because I love Google. But in professional work, I have to go with Microsoft because my university, that's the one. You have to use it until they change again.
So just a show of hands, there are 3 languages in the world: Apple, Microsoft, and Google. Show of hands, how many people speak Microsoft? How many people speak Google? How many people speak Apple?
Can we be multilingual?
Well, Robert, what language do you speak, Bob?
Great.
All 3, okay. So do we
Thank
feel
you.
we have to be multilingual given the number of platforms that are out there? How much of this is a function of institutional choice? We're not going to get fired for buying IBM, was said back before there was email. Or a matter of individual choice about the barriers to entry associated with the cost of buying Microsoft or Apple products versus the freebie Google products. I mean, we've got a number of very interesting issues that come up just looking at this from a blank slate perspective versus, what you have to use at University of Puerto Rico, what you're mandated to use at Scotiabank or at Baker McKenzie or at the state. And how much of this is driven by corporate or institutional factors, security factors, or usability factors? And I'm sure I've left out a half dozen other issues. So you've really posed a very interesting dilemma by articulating these things and by your legitimate and valuable question as a 1L who's trying to navigate all of
Thank
this.
you.
Any other questions? Bob? You, Professor Brescia.
Yes.
Here you go.
Thanks. Just as an aside, I do some work with Microsoft folks and they'll say like, so we'll send you a Teams invite. Is that cool? I'm like, don't worry, I'll send the Zoom. And like, oh, thank you so much.
Well, I left out 2 other languages at least.
But I was delighted to hear for the first time your discussion of access to justice. And that was the first time it was mentioned all afternoon. But I think this question of cost is a tremendous one. And most of the conversation so far, I would frame as B2B right? So business to business, whether it's, including government in there, but we've not talked at all about B2C, except a little bit about the interface with clients and screening clients. So there's a whole nother, there's the tech gap affects low income and working people much more severely than it does law firms, government, or even nonprofits and solo practitioners. So I don't know if people want to respond how we deal with that. I think one potential response is convincing, Harvey does make some products available for nonprofits at a more affordable price, but how can we help nonprofits deliver services to help close the justice gap using tech? Because it's only going to make it worse if law firms and government have the technology and nonprofits do not.
Mildred, go ahead.
I cannot talk about this from personal experience, but in Puerto Rico, there is an NGO called Ayuda Legal Puerto Rico, and they're using technology to help access justice because they are using like making glossaries about legal terms, orientation, and also they have a live chat. So regular people can make questions about legal issues and they have a lawyer answering those questions. And also they have like address directory of lawyers, organizations, etc. And also, I have to say that the Supreme Court of Puerto Rico and the judicial branch and trying to improve the access to justice with different programs, with online courts, sessions, with mediation, alternate dispute resolution. It's not perfect. It's not going to be perfect. And it needs improvement. It needs really improvement because sometimes access to justice can depend on, I'm going to give an example. Recently, there was a case in Puerto Rico when we have COVID, we all moved to online as everybody in every part of the world, United States, etc. But one decision in 2022, and another judge literally, where is Diego? Regañó. Scolded the other judges because this person needed to be on trial. He was one of the, oh my God, my English is going for the above of my testigo. Witness. Thank you. And the witness needed to be online because he had a critical condition of the heart and he was subject still with getting COVID and all that. But the court ruled out that he has to come to the island and be present. So what happened with having online access? What happened to have the witness online and have that access to justice too? So can be funny, can be difficult to combine all these elements because there are a lot of players. And Puerto Rico, we have a lot of people who doesn't have access to internet. And the government is moving to have a lot of services online, not really tailored to all the needs, to all the difficulties we can find. But what happened with old people? Puerto Rico is a place where old people are the majority. And if we don't teach them how to access this technology, we are failing access to justice. And I don't know if I'm answering your question.
Yeah.
But, and it bothers me.
You've
And-
responded to enormous number of questions and raised as many as you've responded. Alejandro?
Yeah, and I just want to add from the knowledge management perspective to access to justice, some of the things that I've noticed from NGOs such as Legal Help Puerto Rico is that they make their legal knowledge accessible to their audience. So they set up libraries where some of these most commonly used documents and samples are available to the community. And they also they have started to implement some of the document automation technologies, and they've automated some of these documents. And I've seen it that they publish, now you have access to X letter for landlord-tenants relations in this particular COVID scenario, for example. And that's some of the ways that, from a legal management perspective, that they're implementing technologies to help the audience, to help the community, making it accessible instead of that one-on-one, let's say, relationship. It's one-to-many, but from an access to justice
And
perspective.
I want to add, a lot of solo practitioners are on Instagram making videos. I don't know how they find the time,
And
but
dances.
maybe a little bit of dances there's in the way, but they are showing and explaining legal issues. Right now, last a couple of weeks was the election in Puerto Rico too, the 5th November. And they made a lot of videos explaining your rights to vote, what can they or they not prevent you to do. So it's important. A lot of lawyers in Puerto Rico are conscious about access to justice. Also, it's a way to get clients, don't get me wrong, but they are proving that we have to make information accessible.
Well, you've raised a couple of very significant issues, one of which is an assumption about a minimum level of technological proficiency of people being able to understand how to use the internet, to see these self-help videos, to be able to access some of these materials. We talked a little bit about a digital divide between generationally in the first panel when we were just focusing on commercial issues. But, this is also a CLE program where implicit in this is a minimum level of technological proficiency among lawyers as well. So we've hit quite a few issues here. I'd like to suggest that we take our end of second session break, bathrooms, and we can resume with the future of technology at 3:10 prompt, and then continue a lot of these discussions during the reception. Because I think what we're doing is we're raising more questions than we're answering. Okay.
Welcome back. This third and final panel, it's gonna be the best one ever. There are no wrong answers. We can make things up because we're talking about the future, and no one yet has won that McLaren go into the future and come back with a sports almanac yet. I am honored to have this group of panelists. We have entrepreneurs, we have journalists, we have programmers, we have access to justice rebels. Is that the term that? Yeah, that's what they call it, right? So I really do appreciate all of you guys joining me for this panel because you wanted to. And I know that we spoke earlier about a few themes that each one of us would bring in. And I was just gonna leave it up to you guys. Just introduce yourself quickly and then jump right in, right?
Where should we go here? I guess since I just started talking, I'll start. So I'm Quentin Stainhouse, and I spent my college years studying computer science, went to law school, spent 12 years as a legal aid attorney. I like to say that there are dozens of us, computer programmers / attorneys, like I'm in that dozen. And now for the last 4 years, I've been at Suffolk Law School in Boston, where I co-direct the Legal Innovation and Technology Lab. A lot of my work there, as you can probably predict from my legal aid background, has been on closing the access to justice gap with technology. I do that in the law school. I also do some of that consulting. I also get to talk to small law firms around the world, I guess, who also want help with technology to solve their problems. Often around document automation is a key technology that we use. So that's me.
Hey, I'm Linda Swan. I'm also one of the 12 programming lawyers. So I'm a lawyer from Australia, but I quit after about a week and became a database programmer and moved to the US. So, but right now I am the director of legal operations at JFrog. We're in the heart of Silicon Valley. We do DevOps, MLOps, security, but in a nutshell, we're the software that all application creators use to organize their software and push to production. So I can say if CrowdStrike used us a couple of months ago, they wouldn't have had that disaster with Microsoft and all the planes being grounded. They were not one of our customers. But in-house, we're a client of many of the big law firms, small law firms worldwide. We are in almost every country in the world. We sell our products. So, and we're very money driven, especially in Silicon Valley. So our budget is a big deal. And the way we interact with our outside counsel, the way we engage them is very much driven in an operational way of what are we investing in, what's the return on the investment, because the bottom line, the stock price is really what drives everything. So that's the perspective I'm coming from. And legal operations, if you don't know what it is, it's a fairly recent, I wouldn't say invention, but it's finally got a name. It kind of grew out of Silicon Valley of people who were helping to operationalize legal within big public companies. So we work on everything from patent strategy, patent portfolio, contracts, lifecycle management is a big one. We run the budget, corporate operations, even board operations. So we cover the whole gambit.
Thank you. My name is Miguel Willis. Currently, I'm the innovator in residence at Penn Carey Law School in Philadelphia. And some of you are maybe wondering what the hell is an innovator in residence. So some of my work focuses on pedagogical innovation within legal education. So getting students to engage in experiential models that kind of cross-cut between social justice, access to justice, and technology innovation, and also thinking critically about various ways we use, design, develop, and apply technology in justice contexts. Some of the work, just yesterday, I worked with our externships and clinic directors to see how we can improve the administration of clinics using Microsoft Copilot and a suite of tools. So thinking about how we can improve the administration of legal education. I do not have a tech background. I got into this work at a legal hackathon in Seattle, my 1L year of law school when I was at Seattle U. And I was exposed to attorneys like the Jason Barnwells and Dan Lears and folks that were very kind of forward thinking. And through that model, developed what I use now as a pedagogical tool, social justice hackathons, getting a bunch of lawyers, advocates, activists, public interest attorneys in a room to address legal challenges and legal issues. Also co-founded a program called the Access to Justice Technology Fellows, which is a national fellowship that kind of engages and equips the next generation of law students, which is open to all law schools, but housed at Penn, kind of in a reboot phase now. And then the latest project I've been working on is trying to build transdisciplinary communities to engage a justice-centered kind of curriculum in AI and what that looks like. I think we as lawyers define justice within specific contexts that make sense to us, access to justice, environmental justice, so forth. Ask a social scientist that same question, they'll have a different answer. Ask a person in business what justice means, they'll have a different answer. And so trying to build faculty coalitions across campus that, work to also build counter narrative digital storytelling and, how can we infuse democratic communities within our work, right? So thinking about when we say we're building tools for access to justice, I think lawyers have a certain context of what that means. The community has a different context. So how can communities shape the direction and inspire their own kind of futures, their healthy futures? I heard that narrative mix today. So yeah, sometimes it's just hanging out in people's offices. Sometimes it's teaching. Sometimes it's hanging out in the engineering department. My job changes every day, but I'm really glad to be here with you all and engage in this conversation. So I'll leave it from there.
Thanks, Miguel. Unlike several of the panelists here today, I am not from Puerto Rico, but I do have to point out that many, many years ago, I practiced law. I had my own law office in the U.S. Virgin Islands, which as islands go is the next door neighbor to Puerto Rico. So same part of the world. But that's not why I am here. I am here because I'm a lawyer, practice law in Massachusetts still, but I'm also a journalist who's covered legal tech for a long time and really kind of followed the evolution of tech from kind of early days. It's really interesting to be on this panel talking about the next 20 years because this is literally the 30th year that I have been writing about legal tech. And what got me interested in writing about legal tech 30 years ago was that was the year that the World Wide Web was released to the public. The internet before that had been this Byzantine, difficult to navigate experience. And suddenly the web came along and changed everything. In those days, the number of lawyers using the web was probably fewer than the number of people in this room right now. But there were early efforts then to try and use the web basically with the goal of trying to democratize access to the law. And as a matter of fact, right up the street here in Cornell, what's that, a few hours up the street here at the Legal Information Institute, the Cornell started something called the Legal Information Institute, which was one of the first entities ever working on trying to make law available to the people online. A little known trivia fact is that one of the first ever web browsers developed was written by the Legal Information Institute as a way of making law accessible to the public. And so, 30 years ago, people were looking at the web as a way of democratizing the law. 30 years later, we sit here now, major corporations are still fighting legal battles over who owns the law. Thomson Reuters is currently involved in litigation against a now shuttered legal tech startup in a copyright suit over who owns the law. State governments are still asserting ownership over the law. So when I start to think about what does law look like, what does the legal practice look like, how can technology impact practice of law over the next 20 years? It's not really that far off into the future. Quentin joked earlier before we started that how long before somebody uses that famous Yogi Berra phrase about predictions are hard to make, especially about the future. There's another sort of famous phrase that a lot of people use that William Gibson, the science fiction writer, said, the future's already here, it's not very well distributed. And I think when we talk about what does law look like over the next 20 years, the seeds of what that looks like have already been planted and they're already germinating. And we really just have to kind of look very carefully around us at what's already happening to see what the next 20 years look like. And I think when we've talked about access to justice here, to me, what's most exciting about the potential over the next 20 years is the potential of technology to really change access to justice. Again, 30 years ago, people weren't really talking about access to justice much. It wasn't front and center as an issue. Obviously, there were low-income people who needed legal help. Even when I was in law school, I worked in clinics providing free legal services to people. But the scope of it, I don't think, was really well understood until more academics got in and started looking at this, at the extent of this problem, and started, putting together these numbers that tell us 80–90% of people with legal problems are not getting help with their legal problems. What did you say earlier? I think it's like 80% of cases in court now are self-represented litigants or something like that. 80 million, okay. I know in certain kinds of courts, the vast majority of litigants are self-represented litigants, small claims courts, that sort of thing. So there's a huge problem out there. And I think we are really at a critical turning point right now. And I truly, truly believe that generative AI is going to be the sort of the secret sauce that's really going to change things going forward and really help us finally make a measurable dent in the justice gap. So I don't think I ever said what I do. Did I ever say what I do and all that? Right now I write about tech. I have a blog called Law Sites and I do a podcast called Law Next.
We had spoken earlier about a few of our potential questions, but something that is unique in this panel is your background in corporate and profit-driven space. One of the things that you mentioned in our conversation was this view of how to account for profit, right? If for us in the nonprofit sector, we're not worried about as much as billable hours. But that's the bread and butter of what every law firm thinks, or at least that's what I think of when you go into the for-profit sphere.
Yeah.
And the conversation that we had was something along the lines, let's flip that. So why don't you, Linda, explain to us what you were thinking?
Yeah, in-house, we're in a kind of unique position where we're very pressured financially to do more with less all the time. To really, we have to scale with the business, and we're driven by corporate objectives, and that can be vary by company, can vary from year to year. But the bottom line that always comes up with it, and now they're adding in AI, it's always, what are your objectives? What are you gonna, what are you going to spend your money on this year? What are you going to invest in the legal department that's going to help you scale? And it always comes along with AI now is the big driver of it. And scaling is a unique issue that throwing technology at it isn't the answer, because it we've sort of found, I've been doing this for about 15 years now. In-house, you need that structure behind any new technology or tool to be able to scale. And to be honest, I'm pretty tool agnostic. A lot of these new generative AI tools that have come out over the last 2 years, they're solving a non-existent problem. So we actually, as a legal operations kind of function, especially in Silicon Valley, we're deeply embedded with the vendors, trying to drive their tools to be able to serve us better. And then at the same time, we put a lot of pressure on our law firms to try and do the same thing and adopt these technologies. We really, really do not like the billable hour. I wish it was gone completely. I would love it to be gone in 20 years. I never have to say it again.
I think it failed.
Yeah, because the biggest thing in-house is we need predictability in our budget, and we want value-driven services. And the legal industry is so far behind where they're not offering like this service cost, this is service cost that. And I think adopting some of these new tools is going to help law firms value their business better so they can make money, they deliver what we need. We get the predictability we need so we don't get in trouble from our CFO, like you're spending too much. I mean, litigation is always going to come up, and there's certain things that we're always going to outsource. Litigation is a big one. I'd love to hear all the eDiscovery stuff going on. Keep at it, because we're never going to do all that stuff in-house. So we need you to get more efficient at that as well. So yeah, death to the billable hour. Love to see it.
Yeah, I'll just kind of follow up and add, I really like the idea of legal operations, and I think it could be scaled to other contexts within the profession, vis-a-vis courts, right? Vis-a-vis legal aid, because both of those institutions deal with limited amount of funding. with this huge kind of crisis and issues that they have to solve and address from. So, and sometimes I think a lot of folks are so interested in how can we develop a tool to solve a particular issue when there's a whole underlying injustice at play. I'll give you an example. In Philadelphia, there, I think, was about, and this is taking the years from 2020 to 2022, a colleague, Professor Hoffman's work, about over 137,000 evictions in Philadelphia. 37,000 of those were default judgment, meaning these folks couldn't get to court because they just didn't show up. Whether that was a missed bus, whether that was they didn't get notice, default judgment. Well, that eviction is going to hunt them for the foreseeable future and employment and credit decisions. And so whether taking the legal centric approach of let's throw a lawyer at this problem, well, let's fix this issue within the courts that gives them the power to break up someone's life through this default judgment mechanism. In addition, examining and interrogating the ways that you have whole surveillance to eviction pipelines that are advancing the scope of evicting people through artificial intelligence. So reducing the injustice in the first place and then looking at the legal system that is a barrier in the first place. And there's a lot of these areas within the legal system or the legal profession that we should take an inflection point to see that we are the problem. And there isn't going to be a tool that is going to solve this problem. There's going to have to be deep-seated change and a deep look in the mirror.
I think that fits nicely with what Bob was mentioning earlier regarding democratizing access to justice. So Miguel brings up really good point regarding the system, the systematic injustice at play that sometimes we just concentrate on throwing a tool at, as opposed to looking at the system. And I was wondering, Bob, how would you frame that within the definition that you propose as to democratizing using AGI into these spaces? How would you, in the best way possible, I hope you solve this issue by your question now, and hopefully we can implement that in our works. No burden, no pressure.
I mean, there's so many layers to that onion, and we could be unpeeling it all afternoon. And Miguel and Quentin are doing a lot of work day to day in trying to tackle a lot of these issues. But I think, I think earlier today you kind of referenced to bilingual tech and legal. There's in the access to justice world, I think a lot of the problem is language. There's a big problem with the fact that we speak legal and most people don't speak legal and don't understand legal, don't even know they have a legal problem is often the case. And so I think, and then there are the literal language issues of the people who don't speak English and resources are only available in English or forms are in English and they don't speak English. So there are all these language barriers that I think AI has real promise to help us kind of overcome those by helping people engage, whether it's with an online self-help site or with a court kiosk or whatever else, perhaps engage in a more conversational way where the software that they're engaging with can better understand them and they can better understand kind of what their options are. Again, I know Suffolk has done a lot of work in this area already. That's been a real focus.
If we had someone from that amazing.
If only we did. If only we did. And then on the language side, I mean, AI is really good at translating, I think that's a real key potential use of this technology is really to just bridge language gaps that come up. I mean, we could speak for the whole hour of just different ways that AI has the potential to create a sort of a better interface between people who need legal help and those who are resources available to provide it. But I think a lot of it is going to start with being able to help people better understand that they have a legal problem, what their options are. You know, Miguel talked about the people who just default because they don't know what to do. This is a huge problem in small claims court where, you know, credit card companies, they have a business of just going into small claims court, suing consumers for these $500 debts or something. Consumer gets a notice from a court. They throw it away. They don't know what to do. They don't show up. And there are now tech platforms out there, like the one called Solo Suit. That's all it does is help people respond to that complaint. Doesn't do anything beyond that. You're on your own after that, but it just gets you to file your answer and keeps that case alive. And even that makes a difference in people's lives. So.
Yeah, yes, it is your turn. All right, jump in to talk about those interfaces because I've translated English legal documents into Spanish and they're still gibberish to my clients. But it doesn't really matter if we're translating English or Spanish or any language, legal to legal. It's that interface what you're referring to. So take it away.
Yeah, I think to some of the discussion that we were having over the course of the afternoon already, like Linda, I think your point about scale is so crucial. And that's, I think, the way that we think about it in access to justice spaces as well, because legal aid programs are very resource constrained. I don't know, those of you who may not already know, right? Like in most cases, there's strict income limits, but even once you take those into account, most legal aid programs are turning away up to 2/3 of the people who qualify based on income because they do not have enough staffing or enough funding. Karen brought up that topic earlier about the right fit and the intake issue. And that's something that I've been working on recently. I think that was a really interesting tie-in. I worked with a legal aid program in Missouri where the problem that they had was one I was really familiar with from being at Greater Boston Legal Services. We would turn on our phone lines at 9 a.m. We would get through a certain number of calls. They would have to turn off the phones at a certain time because they had to call people back who to get them the advice. Often that was by 11 o'clock in the morning. The phones were already turned off for the day. People were waiting on hold for an hour. And then they may not have had that right fit where there wasn't, because we're turning away 2/3 of the people, we were very choosy about which case types we'd be taking. And that would change from week to week, depending on the staffing, depending on a grant that started or ended. So we could have built maybe an expert system to try to tame that mess and say, hey, pre-screen yourself before you call and wait on hold for an hour. And many people have tried that. What I think is really interesting is that now we have this new tool of generative AI. It can actually help free up some of that resource that we have to be on the phone with folks and help figure out that right fit, especially when it's changing really frequently.
Can I stop you for a second? We've heard the term AI. We've heard the term AI, generative AI. Do you want to take a stab at defining? Because it is not the first time that we've used it.
Yeah.
And I think that it's important that because you know what? I think that like they're selling sneakers with AI now. So I just want to be clear in what context we're using it and because everything is AI now. So I just want to make sure we're on the same page.
Yeah, next month I'm going to this AI and law conference that's been running for 30 years. What were we talking about then? It was rules-based expert systems. So that is AI, and I think we can't move away from that.
Now for the people that don't know what rules-based is.
A shortcut now, which is these large language model tools that basically ChatGPT caught our attention 2 years ago. So that's what I'm using that shortcut, but very good point. I talk about LLMs, but in a law school, it's going to confuse everyone even a little bit more because we mean
That's
large
actually
language
after
models.
JD, you get a legal master's degree. Then you can do an LLM there too.
Exactly. Yes. Yeah. So I'm talking about large language models, these calculators on words that we're using. They don't have inherent smarts, but they can do a really good job of transforming words. One thing that we did in Missouri was we said, okay, what are your intake rules for this week? You're giving those to your call center staff already. They're in natural language. Let's have the large language model process those, listen to the person tell their own story in their own words about why they're calling or why they would like to call, and interface those two. So it can do two things. It can either ask a follow-up question if the person doesn't give enough of a story, which is pretty common. You can't really just use an open-ended online intake system because people won't tell you all the facts you need to know. So this will ask follow-up questions, and then finally it will apply and say, hey, based on this week's intake rules, you qualify for help or you don't. I think that's going to be a really interesting way to think about these systems. And like, we're using this in a hybrid approach where there's part of the system that uses the old rules-based approach, the part that qualifies them on income and citizenship. And then we just use the generative AI as kind of this little sprinkle on top to make it easier both to maintain and easier for someone to interact with. So
It improves the conversation, it keeps the engagement going, and hopefully it provides the user or the person seeking help a little bit less of a horrible time knowing that they won't qualify.
yeah, they can use this in 2 minutes instead of waiting on the phone for an hour.
Absolutely. Miguel, do you want to jump in to add a little bit more regarding some of the concerns that you had earlier?
I think we were having this conversation earlier during lunch. There's governance concerns, right? There's probably a scramble across all law firms last week of what are these kind of privacy things that we have to change with this incoming administration. There is, I think, the impacts and harms that we have to evaluate when we're implementing new technology. And that could very well be public interest technology, right? I think it's this kind of notion that just because we have good intentions to use and leverage technology, that it's inherently going to add value to someone's life. That's just not true. And I'm an optimist, so I just want to keep a realist lens in that you can be creating this thing that with the intentions of helping someone escape, this debt collection, but they'll fall victim to this other way that their data is being used and sold to a third party. And so that kind of, I think taking a responsible approach or using the ethical lens, there's privacy, there is evaluating who designs the technology. I mean, I don't want BlackRock ushering in the new access to justice crisis. I'm sorry if anyone works for BlackRock in here. But who's designing it? How is it being deployed? What are the things that we're going to evaluate as benchmarks? I do believe that in a democratic society, communities who will use and who are these tools are designed and intended to be built should have a say in that. And not only in the design, but also the choice and direction we take a strategic approach in solving this crisis. And then there's various mechanisms for evaluating harms in which way, whether folks can opt out of a technology solution. I think that is also another human real concern. And then other panelists mentioned digital literacy, the digital literacy divide. My mom she just got a smartphone, but I had to there was a point where the texting thing is good, the emojis were good, but then when it comes to ordering that Uber, it's a couple steps. And we all think maybe an assumption that an Uber is very easy to order. But when we talk about an aging population, when you talk about folks who don't have a native digital literacy, that can be a very challenging task, right? Even something that's looking on a map at a pinpoint to see, am I here and is the car here? So we really have to not assume that because we work in spaces and we design for spaces that do have a lot of digital literacy, that everyone else is going to have that same type of knowledge base. So those are some of the harms, but there's whole communities who are working on both building rules and standards around these processes, and also trying to, there's the AI Bill of Rights, there's the executive order on responsible AI. So there are frameworks, European, international frameworks that do cover this.
I just want to comment on that. I don't think we've mentioned the H word yet of hallucinations in generative AI. And, you know, I'm sure a lot of you have heard about the Avianca case and all the other cases now where some lawyer who didn't really understand the technology went on ChatGPT and got a bunch of case citations that turned out to not be real cases at all and got in a lot of trouble for that. The problem, a problem or a danger with generative AI is it wants to give you an answer. It wants to please you, even if it doesn't know the answer. So it'll make something up. So when we start talking about using some of these technologies in the access to justice area, where, you know, one of the things I've seen talked about a lot is will generative AI have the capacity to kind of provide direct advice? Maybe we don't want to call it advice because we're all worried about dancing around the
Legal
unauthorized practice rules, but can give people answers to legal questions in some ways. You know, when that's happening in a legal when we as lawyers are using generative AI, then in theory, we know we need to check the results. We need to look at the sources. We need to verify the results. In theory, we're supposed to know that. But consumers aren't going to have that expertise to be able to understand those results. So as we look at deploying these technologies in sort of direct to consumer applications, we have to make sure we really are building in guardrails around that, so that the information that's being provided is trustworthy kind of out of the box without somebody having to go and then investigate and vet it and make sure it's appropriate.
I would love to learn how that looks like within the corporate context, within legal ops of like, how do you make the choices to adopt a new tool or go through this kind of governance evaluation?
Yeah, right now I have a very troubling procurement department and governance group that makes it a little difficult, but we in-house, we really have to have that agile mindset. So we fail fast. And at any point in time, I usually have 3 POCs. That's a proof of concept going with any particular vendor. And I think I have 4 going at the moment with generative AI, but we already use it. Like earlier talking about like playbooking, contracts and templates and knowledge management was talking about that. We already do that. That's like old school AI. But we're already using generative AI. I consider that's creating new work products. It's actually literally redlining the contracts. And that's the space that we're really trying to get to scale at the moment. We're working with all of our contracts, lifecycle management vendors, new AI vendors who just do this in the space and trying to figure out what works, because the LLM model behind the scenes is so key. Because these general ones like ChatGPT, they're not going to give you that legal centric, advice that you need. They're starting to come. There are quite a few brewing in Silicon Valley that we're testing right now. But how do you embed that in the process for the lawyer so it's kind of seamless so that it can scale? It's not replacing the lawyers. But I will tell you what I've seen already with the new, and I think it's only going to continue. Like there's almost no such thing as a paralegal in-house anymore. That role has been eliminated. And if it's still there, unfortunately, it's my job to figure out how to eliminate it, because it's something repeatable that you're doing over and over again. Like a technology should be able to replace that. And we're also putting pressure on our law firms. We stopped paying for law librarians years ago. We stopped paying for secretarial work. We're not paying for paralegals anymore. Like we're moving up the chain, but at the same time, where we invest in our lawyers, not only in getting them to adopt the technology and use it. And you were talking about language, like 50% of my job is an interpreter. Because I speak the 2 languages, I speak IT and I speak legal. So I spend a lot of the time interpreting what the lawyer wants and telling IT, this is what you got to build, because they often build the wrong thing because they don't understand the legal process. But we really try to upskill our lawyers. We want them to do the highest level. We want them to be operating at the highest level that they can, but also, give them a path to progression. And we invest a lot in learning and development. And we're looking at, tools to help us be more efficient in that process as well. So,
and I think that that's a really good mix, because we are, I think, speaking about the same concept in 2 different particular categories of service. You got high end, which I consider anything that you can hire an attorney. For me, that's high end. But the vast majority of the population, I think the numbers were 86%. I think you sent me an article that says that 80 billion people worldwide don't actually know they have an illegal issue, or if they do, they can't access or they can't afford an attorney. But on both sides of the coin, we're looking for those ways in which we can improve.
Yeah.
I'll leave it
I
up to
can
you
jump
guys
in.
and then we'll open it up for the floor.
Yeah.
Just one point on what you just said. It's also important to understand that a lot of the legal problems that people have aren't ones that would ever go to a lawyer in the first place. I mean, they're smaller scale ones. So it's not just that they can't get a lawyer, but it's one that would never be economical for a lawyer to do in the first place, or you wouldn't even really need a lawyer. Often they're just resolving some smaller civil level matter or dispute with a neighbor or something. And I think that's really where some of these technologies can really be powerful. There's that, Quinn, I think you sent me the other day, that the one that kind of mediates, sort of Gen AI tool that can kind of mediate disputes between people. And it's super cool, but it gets rid of, it just helps people resolve disputes on their own directly between each other.
And if it doesn't work, they'll crash the machine. I mean, that's one way to bond too. So Miguel, I didn't know if I cut you off or anything.
Oh, no, I was just gonna say to that point, I think this kind of brings up an interesting point of like non-law firm ownership that I know, non-lawyer ownership of law firms that some people advocate for in the kind of legal innovation spaces as a way to kind of either democratize access, but then actually, taking a second thought, do we want that? I mean, do we want non-attorney ownership? I think for the folks on the corporate end of the ladder that want kind of innovation to come in a more seamless manner, they do. But if we take a look at industries like your industry, journalism, and you see that kind of being severed by hedge funds with AI, and we've just got these kind of newspapers over time, that could be a functional result of this non-attorney ownership kind of debate. So it's actually interesting to think about what are the kind of trade-offs within the corporate scene of looking at that.
Well, I mean, all we know so far are the two test cases of Arizona and Utah, pretty much, where they've both liberalized the rules around that. And the data that's come out of Utah in particular has shown that there's been no detrimental impact on clients, and in fact a very positive impact on people who don't otherwise have access to justice by kind of eliminating the rules on. They have a sandbox, so it's not a permanent eliminate, but they've loosened the rules on non-lawyer ownership and delivery of legal services.
Been doing it for years, and Australia does it too. I think part of the issue, and I come at this from a perspective because I'm Latin American, is there's so much that other people are doing that we should avail ourselves of, we should be looking at and learning and your previous I don't know that point. And it goes back to something you mentioned earlier, democratizing access to justice. You're not going to get it there as a you, because again, I'm coming from outside the border. You're not going to get it there until AI can pierce corporate ownership of the law. That means laws, regulations, case law. I applaud the notion that AI is going to help people kind of litigate without lawyers. But you can't litigate unless you know what the rules are. You can't know what the rules are unless you can afford to pay to play. And everything in the US is behind a paywall. In Canada, it's all freely available. A court issues a judgment, it goes into Canley, and it gets published.
They filed a lawsuit last week against the startup, but
But so I think there's some fundamental, to your point, there's some fundamental issues we have to resolve. And AI is not going to resolve them unless we look at the fundamental business of law. Let anybody own a judgment from the Supreme Court of New York or whoever.
Yeah.
The answer has to be no, if justice is going to be available to everyone.
One of the things that I think about a lot and it ties into that a bit. I mean, first, I'll just say as an aside, I don't know how much that case law matters for most problems people have. So I think we have to acknowledge that people may not need to know the legislation for sure. And there are some states that have some very troubling ownership rules there around the annotations, at least, of the statutes. But, you know, right now we have around the world, lawyers are mostly practicing like shoemakers were a couple hundred years ago. And I think that's the scale problem that we have to address, right? We're looking at what are the generative AI tools that are coming out. Mostly they're assistive tools for lawyers. Great, you can build that one shoe a little faster, but you're still like one-to-one where someone's gonna have to meet and talk to the person and figure out, well, what do you want your shoe to look like? Meanwhile, shoes have moved on so far, right? Like we're buying them off the rack and people line up around the block for that mass-produced shoe. It's not like it's worse quality. It's just a different model. And I think we do have to break that ownership part for part of that. We also have to open up unauthorized practice of law to recognize law should be able to be produced as a product for those low-level consumer tasks, if nothing else, so that people don't need to go through the rigmarole of sitting with an expert to solve a dispute over noise complaint in their condo, or do I get to have the children over Thanksgiving, right? I don't think that we have a good model fundamentally to solve those problems right now.
So the law doesn't need to be everywhere.
Yeah.
In a way, I mean, that's my solution. So.
At least not lawyers. At least not lawyers.
So, I will open it and continue the conversation. Yeah, sorry.
All right, so my question is, what's, you know,
The mic.
you're the experts.
I'll be the, go.
David, tell them what you do.
I do all the things. So my question is what do we lose in developing new technologies in the next 20 years? And I'll give you an example. So I'm the director of the law library here. I teach advanced legal research. I have people come up to me and they say things like, can you help me? I'm trying to find Boolean terms for this particular search, get particular results. And sometimes there's results because there's actual case law. Sometimes there's not, but a lot of this, I don't give them the terms. I say, all right, there's this thing called the key number system, right? So let's look at the key number system. And every single time I find what they're looking for without resorting to Boolean. And I think Boolean's great. There's times when I've used Boolean searching, because I don't just use one thing, but what I'm saying, and now we have AI, we have generative AI to do another thing. I think we need to learn how to use all the tools because sometimes we're missing out. Like the tools should be created to solve problems, not make things faster. We generally use tech just to do what we do now faster. But in making things faster and adopting new tools, we seem to lose out old skills, right? And what skills are we going to lose that we have now in the next 20 years?
I mean, I'll just jump on that. I mean, and Miguel, I'm sure you could too, like being in a law school. I think, yes, right? Like right now, we're in this transitional phase, maybe. Someone who was teaching 20 years ago would say, you need to know how to use the books. Maybe not even 20 years ago. I mean, I wasn't quite that long ago in law school and we were still using the books, but we were mostly using the databases, right? So is that skill still going to be relevant in 10 years? You need to know it now. You might need to know it for the next 10 years, but after that, maybe not. And we gotta be able to understand that there are some skills that are just going to become more specialized, less crucial for the day-to-day. The biggest challenge is we don't yet know what things we can safely use generative AI for. I have this mental benchmark where most of the time I find, hey, with a little work, I can get to 80% accuracy. That's pretty good for a lot of things. It's not good enough for a lot of other things. So does that mean you have to know how to do it manually, but you're just going to spend 20% of the time you used to in law school learning how to do it the manual way? Or we're like, well, maybe it's okay. I don't know. How good are people at those same tasks? Is honestly not much better than 80%, if that, we just don't measure them as closely. So we may have to change the way we look at what is the work of lawyers, maybe how we specialize to do those same things that are really important skills we still need. Not everybody may need them to the same level they do now.
Yeah, in legal ops, it's kind of it's a data-driven question. And we have this concept of get rid of the rot, open up the sun, and rot is data that's redundant, useless, I can't remember, and something else. And the sun is like, it's sensitive, usable, and necessary. And you want to get to that as fast as possible. And getting to that as fast as possible, AI is absolutely going to change that game. So you're only analyzing the 20% that really matters at the end of the day. And I can't imagine anybody wants to deal with the 80% of rot. Nobody does. And it's a big problem in corporations as well, because our data lake is so huge. And you're trying to make data-driven decisions. And I think not just even in the corporate area, but I think everybody in your life, like sometimes it's a gut feel decision, but 90% of the time it should be data-driven. Like, what should you do next? What's going to help me get from A to B faster? You know, which process works better? So that sun versus rot is a big thing that we're trying to figure out with a lot of our generative AI vendors as well, to help us make sense of ridiculous amount of data. And email should be dead as well. Yeah. Yeah.
And just to add to these great points, I think one, we're seeing an uptrend of what the skills of law students are coming into law school have, right? I've taken both law students, I think 35% across all law schools have technical backgrounds. But then thinking about how can we use tools to teach skills? And I'm building out a module that will have people look at a justice technology, but then examine it through its history, kind of racial, socioeconomical context, and also place, right? But they're using some will be using Canva to describe that visually, right? And that's but if we think about just teaching law students how to use tools, they become kind of this adaptive, functional kind of cog, right? And so, yeah, I think the tools help facilitate the work, but you can use and leverage the tools to teach deeper skills, whether it is looking at or evaluating justice, whether it is critical analysis, or just technology in general, evaluating the kind of technology harms, right? We were having that discussion about Google and Microsoft and Apple. All three of these companies are perpetuators of surveillance state, of all types of harms that they're being actively litigated against in federal courts and state courts across America. So there should be at least some critique or interrogation of what are the trade-offs of using either one of these tools from an ethical lens, and what are those kind of privacy considerations. So.
I just want to quickly add to the last point. With these new tools, we're going to have new types of skills. So with Gen AI, for example, prompt engineering is probably going to be the new Boolean search. So we're going to have to address these new tools with new types of skills, and we're going to have to, let's say, address how we teach the skills, because with Gen AI, we're not sure how exactly to surface that information correctly to get from like 70% accuracy or 80% or 90%. So how you prompt with these tools is going to be very important. So just want to add that.
I really worry when you said that you're not hiring more paralegals. And that in a sense that in my work, I work with diversity students, not necessarily comes from lawyering background. And paralegals usually are the diversified group, and usually it's the step up to be a lawyer. So we are losing this low in the chain of command. We lose this type of job. Maybe we are ending diversity in the profession.
I wanted to add to both of those points, and I think this is a really interesting conversation that we could have for like another 13 years. And my background is more of a criminal defense, and obviously I did from that point. I had a great time becoming an abolitionist, and now I study decolonial theory. So these things, as to prompt engineering, which is a skill that we are expecting lawyers or future lawyers to have, what do we lose by the question, right? The question is, well, we may lose critical thinking skills for our students. We may lose diversity when it comes to, and when we have these groups of organizations also controlling what we build, what we use, and how it's deployed in different skills set based on certain parameters established by those players, then we do miss out on the democratic process. We don't have a choice, but we're using, or we're being used, right? If now everything's a surveillance. There's a book called Surveillance Capitalism that talks about how the world of ad tech, which is Google, which is Facebook, which is Meta, and others, right?
I will just
Quantify
say
it,
though, right?
yeah.
We've been having this debate about losing skills for 3,000 years, right? Socrates was like, we can't write stuff down. Writing is a horrible invention. You have to orate and memorize these long versions of what you
No,
think.
and I just think that I think there's enough room to have these debates. And I think I encourage everyone to continue on questioning not only the utility, the efficiency models, but also to learn how to do prompting so that you're not just talking out of your hate, which is where I come from sometimes. But I think it is important to have that balance. And I think that these conversations, as I said, could go on for the next 20 years, right? And we will be having these conversations, hopefully, if they're still in the United States of America the next 20 years. So I think that it's a good time to end at this time. I want to again thank all the panelists, all our guests, all the faculty members, and all the students that I have forced to come in. I appreciate everyone's presence here today. Please join us. We're going to have a small reception right outside. So thank you once again for joining.